federal prosecutor handling the largest money laundering case in the Southern District of New York. Family targeted 72 hours before trial. Intelligence confirms professional surveillance team watching the family for 11 days. Spouse photographed leaving work. 3 children photographed at school pickup. Home address, vehicle descriptions, and daily schedules documented in files recovered from an encrypted server linked to Eastern European organized crime. Kidnapping plan. Intercepted. Take children. Saturday morning during soccer practice. Video torture to force case dismissal before Monday trial. Marshals Service has 72 hours to secure a family of 5 before the operation executes. If delayed, 3 children, ages 6, 9, and 13 abducted. Prosecutor forced to sabotage case worth 18 months of investigation. The case had begun with a single suspicious transaction flagged by a compliance officer at a Manhattan bank. $14 million wired from a shell company in Cyprus to a real estate holding firm in Delaware. The compliance officer noted irregularities in the documentation. The beneficial ownership was obscured behind layers of corporate structures. The stated purpose of the transfer did not match the pattern of previous transactions. A suspicious activity report was filed. Most such reports lead nowhere. This one led to the largest money laundering prosecution in a decade. Over 18 months, federal investigators traced a network of shell companies spanning 14 countries. The money originated from sources in Russia, Ukraine, and Kazakhstan. It flowed through banks in Cyprus, Latvia, and the United Arab Emirates. It landed in American real estate, American businesses, and American political campaigns. The total amount laundered exceeded $2 billion. The scheme had operated for nearly a decade without detection. At the center of the network sat a figure investigators came to know well, a financier with offices in London, Moscow, and New York, a man who attended the same charity galas as senators and diplomats, a man whose donations had purchased access to the highest levels of American political and business circles, a man who had built his fortune managing money for oligarchs who could not openly hold assets in the West due to sanctions and criminal investigations in their home countries. The financier was not the target of the prosecution. He was the cooperating witness. Facing decades in federal prison and the seizure of everything he had built, he chose to provide testimony against his clients, the oligarchs whose money he had hidden, the corrupt officials whose bribes he had laundered, the criminal networks whose proceeds he had washed clean through American financial institutions. The trial was scheduled to begin Monday morning. The financier would take the stand Wednesday. His testimony would implicate 3 oligarchs currently under international sanctions, 2 former government ministers from a former Soviet republic, and a network of American lawyers, accountants, and real estate developers who had facilitated the laundering operation. The defendants had hired the most expensive legal teams available. They had filed motion after motion seeking delay. They had challenged every piece of evidence. They had lost at every turn. Now, with 72 hours until trial, they had chosen a different strategy. The prosecutor assigned to the case had spent 3 years building it. Every document reviewed personally, every witness interviewed multiple times, every financial trail followed to its origin. The prosecutor understood the case better than anyone alive. Losing this prosecutor meant losing the case. A replacement would need months to prepare. Witnesses might recant or disappear. Evidence might be challenged on grounds the replacement could not effectively counter. The defendants understood this calculus perfectly. Surveillance on the prosecutor's family began 11 days before trial. A team of 4 operatives, all with backgrounds in intelligence services from former Soviet states, established positions around the family's suburban home in Westchester County. They photographed the spouse leaving for work each morning. They documented which car was used on which days. They noted when the housekeeper arrived and departed. They recorded the license plates of every vehicle that visited the property. The children received special attention. The 13-year-old attended a private school in Manhattan, commuting by train with a group of classmates. The 9-year-old and 6-year-old attended a local elementary school, dropped off by the spouse each morning, and picked up by the housekeeper each afternoon. On Saturdays, all 3 children played in a youth soccer league at a park 2 miles from home. The surveillance team documented every detail of this routine. The plan, intercepted by federal agents, was clinical in its precision. Saturday morning, during soccer practice, 2 operatives would approach the children, while a third disabled the housekeeper's vehicle in the parking lot. The children would be told their parent had been in an accident. They would be led to a waiting van. By the time anyone realized what had happened, the children would be in a safe house in New Jersey, beyond easy reach of immediate search efforts. Once the children were secured, a video call would be placed to the prosecutor. The children would be shown, frightened but unharmed. The demands would be simple. Announce a conflict of interest requiring recusal from the case. Recommend dismissal based on newly discovered problems with evidence. Sabotage the prosecution completely. If these demands were met, the children would be released within 48 hours. If not, videos would be sent. The plan did not specify what those videos would show. It did not need to. The intelligence that revealed this plot came from an unexpected source. One of the surveillance operatives had a gambling problem. He owed money to people who did not forgive debts. Those people had connections to an FBI informant embedded in Brighton Beach's Russian-speaking criminal community. When the operative mentioned a big job coming up, one that would pay enough to clear his debts, the informant listened carefully. When he mentioned children, schools, and a prosecutor, the informant contacted his handler immediately. The FBI passed the intelligence to the U.S. Marshals Service at 4:15 p.m. on Wednesday, 72 hours before trial. By 5 p.m., a threat assessment team had confirmed the credibility of the intelligence. By 6 p.m., the decision was made. Full protective custody for the prosecutor's family until trial concluded and the threat could be neutralized. The prosecutor was informed at 7:30 p.m. during a routine security briefing at the federal courthouse. The reaction was immediate and visceral. The prosecutor demanded to call home. The marshals advised against it. The spouse's phone might be monitored. Any change in routine might alert the surveillance team. The extraction needed to happen without warning, a sudden disappearance that would leave the operatives watching an empty house. At 9:15 p.m., a convoy of 3 unmarked vehicles departed the federal courthouse in Manhattan. The prosecutor sat in the middle vehicle, flanked by 2 deputy marshals. The drive to Westchester took 47 minutes. The prosecutor spent the entire journey staring at a phone, forbidden to make calls, watching the minutes pass. The family was extracted at 10:22 p.m. The spouse answered the door expecting a delivery. Instead, 4 deputy marshals stood on the porch, credentials displayed, voices calm but urgent. The children were awakened and dressed. Bags were packed in minutes. The housekeeper was told to go home immediately and speak to no one. By 10:45 p.m., the family was in the convoy, heading toward a secure location in Connecticut. The children asked questions the entire drive. The 6-year-old wanted to know if this was an adventure. The 9-year-old wanted to know when they could go home. The 13-year-old, old enough to understand something was seriously wrong, sat in silence, watching the parents exchange looks that communicated more than words could. The surveillance team watching the house noted the unusual vehicle activity. They reported to their handlers that something had changed. They were instructed to maintain positions and observe. By morning, they would realize the house was empty. By then, it would be too late. Thursday morning, the prosecutor appeared at the federal courthouse as scheduled. Pre-trial motions were heard. Jury selection procedures were confirmed. The defendants sat at their table, expensive suits and confident expressions, unaware that their backup plan had already failed. Their lawyers filed last-minute motions seeking continuance. The motions were denied. Trial would proceed Monday, as scheduled. The family remained in protective custody at a secure facility in rural Connecticut. The children were told they would miss school for a few days. The spouse, now fully briefed on the threat, struggled to maintain composure in front of the children. The prosecutor visited Thursday evening, staying 2 hours before returning to Manhattan to prepare for trial. Meanwhile, the FBI and Marshals Service coordinated an operation to neutralize the surveillance team. Agents identified all 4 operatives through a combination of facial recognition, cell phone tracking, and old-fashioned physical surveillance. The operatives were staying at 2 separate motels in Westchester County. They drove rental cars registered to fake identities. They communicated using encrypted messaging applications. They believed they were invisible. Friday morning, arrest warrants were issued. The charges: conspiracy to commit kidnapping, conspiracy to obstruct justice, and acting as unregistered agents of a foreign power. Federal agents moved on both motel locations simultaneously at 6 a.m. 3 operatives were taken into custody without incident. The 4th, the one with the gambling problem, attempted to flee through a bathroom window. He was apprehended in the parking lot, still wearing only boxer shorts, by 2 deputy marshals who had anticipated exactly this response. Searches of the motel rooms yielded extensive evidence. Photographs of the prosecutor's family numbered in the hundreds. Detailed schedules documented every movement over 11 days. Maps showed routes to and from schools, the soccer field, the spouse's workplace. A burner phone contained text messages in Russian discussing the kidnapping plan. A laptop held encrypted files that, once cracked, would reveal communications with handlers overseas. The 4 operatives were transported to the Metropolitan Detention Center in Brooklyn. They were held without bail pending trial. Their handlers, receiving no response to encrypted messages, understood that the operation had failed. Within hours, 3 of them boarded flights to destinations outside U.S. jurisdiction. The 4th, the one who had organized the operation from New York, was arrested at JFK Airport, attempting to board a flight to Istanbul. His luggage contained $400,000 in cash and documents for 3 separate identities. Saturday, the day the kidnapping was supposed to occur, the prosecutor's family remained in protective custody. The children watched movies. The spouse paced the facility's small courtyard. The prosecutor drove up from Manhattan for a longer visit, staying overnight. For the first time since the extraction, the family ate dinner together at a table in a government safe house, surrounded by armed federal agents, trying to pretend this was normal. Sunday, the prosecutor returned to Manhattan for final trial preparation. The defense team, now aware that their client's backup plan had catastrophically failed, requested an emergency meeting with the judge. They claimed newly discovered evidence required delay. The judge, already suspicious of the timing, denied the request. Trial would proceed as scheduled. Monday morning, jury selection began. The prosecutor delivered an opening statement that laid out 18 months of investigation in clear, compelling terms. The defendants listened, their expensive lawyers taking notes, their confidence visibly diminished. The cooperating witness sat in a holding area, waiting to testify, protected by marshals who understood that he too remained a target. The trial lasted 6 weeks. The prosecutor presented evidence methodically, building the case document by document, witness by witness. The cooperating witness testified for 4 days, describing in detail how billions of dollars had been hidden from international sanctions, how American financial institutions had been used to clean dirty money, how the defendants had knowingly participated in a scheme that enriched criminals and corrupt officials at the expense of the rule of law. The jury deliberated for 3 days. They returned guilty verdicts on all counts against all defendants. Sentencing would come later. Prison terms measured in decades awaited men who had believed themselves beyond the reach of American justice. The prosecutor's family returned home 2 days after the verdict. The children went back to school. The spouse returned to work. Life resumed something approaching normalcy, but the family would never forget those 72 hours. The knock on the door at night, the hurried packing, the drive to an unknown location, the fear that something terrible was about to happen. The surveillance operatives pleaded guilty to reduced charges in exchange for cooperation. They provided information about their handlers, about the network of former intelligence officers who hired themselves out for operations in the West, about the methods used to identify and track targets. This information would prove valuable in future investigations. The organizer arrested at JFK received a 15-year sentence. He would serve his time in a federal facility far from any city with a significant Russian-speaking population. His clients, the oligarchs who had ordered the operation, remained beyond reach. Protected by governments that did not recognize American extradition requests, but they had lost billions in seized assets. They had lost their American lawyer and accountant networks. They had lost access to the financial system that had allowed them to enjoy their wealth in the West. What was prevented? 3 children, ages 6, 9, and 13, were protected from abduction by a professional kidnapping team with intelligence service backgrounds. A family was spared the trauma of violent coercion designed to force a federal prosecutor to sabotage a major case. A prosecution worth 18 months of investigation and billions in potential asset recovery was preserved through trial to successful conviction. If the marshals had delayed even 24 hours, the surveillance team would have executed their plan during Saturday soccer practice. 3 children would have been taken from a public park in broad daylight. A spouse would have received a phone call describing horrors that no parent should ever have to hear. A prosecutor would have faced an impossible choice: career and justice, or family and surrender. The intelligence came through channels that rarely produce actionable information: a gambling debt, a careless comment, an informant who happened to be listening at the right moment. These small threads wove together into a warning that arrived with just enough time to act. 72 hours. That was the margin between a family enjoying Saturday morning soccer and a family torn apart by violence. Instead, the children played their games, unaware of the danger that had passed. The 9-year-old scored 2 goals. The 6-year-old picked dandelions on the sideline. The 13-year-old complained about having to wake up early on a Saturday. Normal childhood moments that almost became the last normal moments they would ever have. The U.S. Marshals Service protects hundreds of federal judges, prosecutors, and witnesses each year. Most protection details are precautionary, responding to threats that never materialize into action. Some, like this one, involve active plots that require immediate intervention. The difference between a precautionary detail and an emergency extraction is often measured in hours. In this case, 72 hours separated routine protection from catastrophic failure. The prosecutor continued working major cases after the trial concluded. The family continued living in the same house. Though security measures were enhanced, the children continued attending the same schools, though parents now looked more carefully at the cars parked near the pickup line. Life returned to normal. But normal had been redefined. The defendants appealed their convictions. The appeals were denied. The sentences were upheld. The oligarchs, whose money had funded the operation, watched from abroad as their American empire crumbled. The lawyers and accountants who had facilitated the scheme faced their own prosecutions. The ripple effects of the case continued for years, but for one family, the case ended on a Saturday morning when 3 children played soccer without knowing that armed federal agents were positioned at every entrance to the park, without knowing that the people who had planned to take them were sitting in federal custody, without knowing how close they had come to a nightmare that would have changed everything. That is the nature of protection. When it works, the protected never know how much danger they faced. They never see the operatives watching their home. They never read the plans describing their abduction. They never understand the margin between safety and catastrophe. 72 hours. That was all the time the marshals had, and that was all the time they needed.